chasing dreams.
Good morning and welcome. I'm glad you're here. This is the very first episode of The Forecast. If you're tuning in, it's because you care about law enforcement, the law itself, and the way we carry ourselves in this profession. Every week, I'll step back from the noise of the headlines and the rush of the shift to give you a briefing. Think of it like a weather report for policing. Not rain and thunder, but the pressure that builds, the fronts that collide, and the storms that test all of us. So grab a cup of coffee, settle in, and let's take a look at this week's conditions. This is the Condition Report, Episode 1 of The Forecast. Your weekly weather report for law enforcement, and before we begin, a disclaimer. This podcast is for educational purposes only. It is not legal advice, and I am not speaking for any government agency, department, or entity. I speak only on behalf of Forecast Securities Group, LLC, the training and consulting company that I represent. Nothing here should ever substitute for a qualified legal counsel when it comes to real-world incidences. Here's the structure that you can expect from each week. We'll start with the statutory climate, the laws on the books that set the baseline. Then we'll move on to the legal front, the cases where those laws collide with reality, where the storm breaks. And after that, we'll step into the leadership climate, the principles that steady us when the pressure rises. And finally, we'll close with an extended forecast, the lessons that we carry forward into the next week ahead. I'm Don, and this is the forecast, because in this work, we don't simply stand in the weather, we influence it. Let's start episode 1 with the statutory climate. The statutory climate today comes from California's Welfare and Institutions Code, Section 300, defines when a child can fall under the jurisdiction of a juvenile court. Abuse, neglect, serious risk of harm, emotional abuse, sexual exploitation, or abuse of a sibling. These are the grounds. And the statute is careful. Poverty, homelessness, or financial hardship are not enough. Struggle is not abuse. That distinction matters because the law is clear that intervention is for the protection, not for punishing a family that is poor. Then we move on to Section 340. That's the authority for a protective custody warrant. If a Section 300 petition has been filed and the court finds danger in the home, a protective custody warrant can be issued immediately. Even without a petition, a judge can still issue one if the 3 elements of probable cause exist. First, that the child meets the definition of Section 300. Second, that child faces substantial danger. And third, that there is no reasonable alternative. Now, once a child is taken under this authority, the law says they must be delivered immediately to a social worker. That social worker is tasked with investigating and, when possible, trying to keep the child with the family. That's the baseline climate. But here's where things start to shift. These warrants are civil. They're not criminal, and that's an important distinction. Penal Code Section 1533, which limits the nighttime service of criminal search warrants, does not apply. And unlike criminal warrants, these civil custody orders do not have to list a specific address. The warrant follows the child. Plainly, a child may be taken into custody from any location, a home, a school, or even a public place. Still, this flexibility is not immunity. Civil does not mean unchecked. Entering a home is still a search. Taking a child is still a seizure. And when the government orders an invasive medical exam, that is one of the most intrusive searches it can perform. The statute tells us when authority exists, but the Constitution still tells us how far the government can go. That's the statutory climate, the baseline weather pattern. And it sets the stage for our first case, because statutes alone do not prepare us for the storm. We need to see how those conditions actually collide in the field. And that takes us into the legal front. In September of 1991, Bill and Becky Wallace were living in San Diego with their 2 children, Lauren and Jesse. An ordinary family, steady jobs, everyday life. But the first gust of the storm came from Becky's sister, Rachel. Rachel suffered from severe psychiatric illness. The year before, she had accused Bill of molesting Lauren. CPS investigated and found no evidence. The Wallaces then cut ties. By 1991, Rachel was hospitalized. She told her therapist, Candace Young, that Bill planned to sacrifice Jesse to Satan on the fall equinox, cover it up with a staged car fire, and that her family was part of a cult. She even added a so-called memory from the 1970s, years before Jesse was born. Young, as a mandated reporter, passed this story to CPS. The hotline note itself documented Rachel's diagnosis of multiple personality disorders and even warned that she decompensates during cult holidays. Despite these warnings, the case moved forward. Social workers contacted Escondido Police Department. Detectives were told that there was a court order to remove the children, but there wasn't. Still, the assumption became as good as fact. On September 22nd, officers followed Becky home from work. She noticed. She grew frightened. She even drove to a police station for help, too scared to get out of the car. Officers eventually stopped her and told her they needed to check on her kids and persuaded her to bring them to the home. Near midnight, they entered the Wallace residence. The kids were asleep. They looked well cared for. Nothing suggested danger. Still, Detective Diana Pitcher woke Lauren and questioned her, and heard nothing about abuse. Yet moments later, the parents were told their children were being taken because of the quote-unquote order. At 1 o'clock in the morning, Lauren and Jesse were placed into county custody. 3 days later, on Jesse's third birthday, the children were taken to Palmer Hospital. Without a court order, without parental notice or consent, Dr. Mary Spencer performed an invasive medical examination. Photographing their bodies, her report claimed that there were signs of molestation and stated that another doctor, Susan Horowitz, had concurred. But months later, Dr. Horowitz corrected the record. She stated that she had not concurred, and after a full review, she concluded that there were no evidence of abuse at all, and that Spencer's findings had ordinary medical explanations. The entire case collapsed. On December 6th, the children were returned home. But for the Wallace family, the storm wasn't over. They filed a civil rights lawsuit under Section 1983. The Ninth Circuit of a Court of Appeals ruled that the seizure and the medical examinations were unconstitutional. Qualified immunity was denied. The court held that even in 1991, the law was clearly established. Children cannot be removed from their homes without a court order unless there is imminent danger. And children cannot be subjected to invasive medical examinations without parental consent, a court order, or true exigent circumstances. In plain terms, the officials involved could be held personally liable for damages. The storm carried consequences, but not just for the Wallace family, for the officers and social workers who rushed forward on assumption. That's the legal front. And from here, we step into the leadership climate. From Wallace v. Spencer, we draw this principle: the stillness of the storm. A storm rages because winds collide. Yet above the clouds, above the sky, is calm. Leadership is found in that calm. Noise is not action. Panic is not progress. The loudest storm often passes the fastest. Stillness does not deny the storm, it endures it. And by enduring it, governs it. For officers, the meaning is clear. When others rush with assumption, you stand with clarity. When pressure drives panic, remain calm. Calm is not weakness. Calm is strength, disciplined into stillness. That is the leadership climate draw from this case. So now we close with the extended forecast. The statutory climate. Welfare and Institution Code Section 340 gives civil authority for child protection warrants. They may follow the child anywhere, but they remain bound by the Fourth Amendment. The legal front, Wallace v. Spencer, showed how mistaken assumptions and unchecked urgency lead to unlawful seizures, unconstitutional medical exams, and liability for officers who fail to respect limits. And leadership climate. The stillness of the storm. The leader does not add to the wind. The leader steadies the air, creates space for clarity and lawful action. So in short, if you guys are serving these warrants, if you're participating in the service of these warrants, I suggest you and your organizations get together, refine a policy that dictates how these are served, what time of day they're served, and in what manner they're served with what level of force, if any. I'm Don. This has been the Condition Report, Episode 1. Be the calm in the storm, the clarity in confusion, and always influence the weather. Goodbye.
We can do better. We could be chased.